Hello and welcome everyone. Good evening everyone. कैसे हो आप सब? Just give me a thumbs up कि whether I'm perfectly visible and audible to you all. जल्दी जल्दी thumbs up कर दीजिए. Okay. चल, let us start with the first passage and let us see कि कितने passage हो पाते हैं with respect to our time limits. We'll be doing these passages on the law of torts. So I think अभी तक आप सबका law of torts हो गया होगा, कुछ बचा नहीं होगा. I'm really hoping that क्योंकि static legal knowledge तो वैसे भी it's easier to do than legal current affairs. So we'll do some certainly similar type of questions जो CLAT के अंदर होते हैं, ठीक है? So first we will be going ahead with our first passage that is on defamation, which will include libel and slander both. ठीक है? So what I'll do is we'll all read the passage together and then we'll solve the questions together. ठीक है? तो कोशिश करना कि let us read in a faster manner, right? हम पेज थोड़ा ज्यादा रखेंगे क्योंकि हमारे पास बहुत सारे क्वेश्चंस है करने के लिए. ठीक है? So the first passage is basically stating the defamation, what defamation is. जो अगर आपको ऐसा लगता है कि पैसेज में ऐसा कोई टॉपिक है जिसके बारे में आपको ऑलरेडी पता है, तो जस्ट गो थ्रू एंड सी द एसेंशियल्स कि आपको ऊपर से स्किम रीड करके आपको क्या क्या समझ आ रहा है. सो वी कैन सी यहाँ पे डेफेमेशन की स्टेटमेंट दी गई है जो सेक्शन 4499 में आईपीसी के अंडर दी गई है. हमको ऑलरेडी पता है कि डेफेमेशन कैन बी बाय स्पोकन और रीडिंग, साइंस, विजिबल रिप्रेजेंटेशन, इन सब के थ्रू हो सकता है. क्या होता है ये बेसिकली इफ मेक्स और पब्लिशेस एनी इम्प्यूटेशंस कंसर्निंग एनी अदर पर्सन. तीन एसेंशियल्स होते हैं कि दिस हैज टू बी अ स्टेटमेंट हैज टू बी स्पोकन अबाउट द अदर पार्टी एंड इट हैज टू बी पब्लिश्ड. ठीक है, कुछ मेजर ही इसके एसेंशियल्स हैं. लिबल, स्लैंडर है और स्लैंडर पर से, ये तीन टाइप के इन्होंने हमको डेफिनेशन बताए गए हैं. लिबल इज यू ऑलरेडी नो व्हाट रिटन और परमानेंट इज. ठीक है, स्लैंडर इज स्पोकन, अगर हम किसी को बोल के किसी को डिफेम कर रहे हैं, दैट इज स्लैंडर. And slander per se is basically certain statements are so inherently harmful that a special damage need to be proved. कुछ special damages होते हैं जहां हमको prove करना होता है. देखिए पूरा gist बता दिया मैंने एक पैसेज के अंदर. This is what you do as a skim reading. ये आपका 1 मिनट में हो जाना चाहिए. ठीक है. Moving on, questions भी similar होंगे. बस ये जो pointers दिए यहाँ पे इनको टिक मार्क करके रख लेना. ठीक है. So the first question is basically the baker's board. X and Y were two bakers, okay, and they were bakers where in Canterbury. After Y moved his bakery directly opposite X, X put up a board stating the try fresh breads from my bakery. The rotten smelly breads of Y are not worth your time. Y claims he has been defamed. तो यहाँ पे क्या बोल रहा है कि Y बोल रहा है कि नहीं मेरे को तो डिफेम कर दिया है, राइट? नाउ वी नीड टू अंडरस्टैंड कि क्या ये डिफेमेशन था या नहीं था. भी हमारे जो कितने दो या तीन एसेंशियल्स है कि द स्टेटमेंट शुड बी देयर, द स्टेटमेंट मस्ट बी पब्लिक एंड इट शुड बी समथिंग दैट हार्म्स द रेपुटेशन ऑफ द अदर. ठीक है, क्या ये तीनों चीजें फुलफिल हो रही हैं? यस, ऑल द थ्री थिंग्स आर फुलफिलिंग. दैट्स व्हाई द करेक्ट आंसर हियर इज ए. ओके, so the answer would be A here. Moving on to question number 2, that states in the same question, in the same Canterbury scenario, instead of board, X made a boy stand outside and yell, please come to our bakery, beware on the other side, they are rotten and smelly breads. Y wants to file a defamation case against X. So here, क्या defamation होगा? Of course, this boy standing outside the store and boy is what? Yelling about how the other side has rotten and smelly bread, so you should not go and buy them. So imagine if there are two stores and both of the stores sell the similar article and they are side by side, adjacent to each other, right? So what we are going to do, we are going to, if one of the person comes and say नहीं इसके वहां से तो नहीं लेना, ये तो खराब चीजें देता है, इसके वहां से लेना है, ये तो सही चीजें देते हैं, right? So वहां पे of course it is defamation and you are just yelling and telling it to the other people and it is basically harming the reputation. So answer is going to be C here. Question number 3, the collision chief minister. Ramu Kumar, chief minister of Patliputra, changed his political alliance to protect his position. Tejasvi Pratap at a public gathering said Ramu was a fraud and liar who changed his colors according to me. Has Ramu been defamed? So here, I think because there is political alliance, and of course, it was Ramu was a fraud and liar who changed his colors according to time. Here the answer is going to be A, because there has not been defamation for Ramu in the given case. Why? While the statement, while harsh, arguably reflects a reasonable opinion based on publicly known facts. So majorly, it was a public known facts. You might read articles about someone. Okay, these are the statements that are saying. So that is not supposedly to be, a defamation. You know that there are critics who write critical arguments and everything and stuff. So majorly, you are reading the similar things in the editorial section of the Hindu, right? So there are movie critiques. You can see the critiques to be done for any artist or anything, right? So that is also there. Opinion versus defamation. In the same political scenario, Tejasvi Pratap comments in public, it seems Ramoji is more interested in concentration of power than actual development. Can Tejasvi be held liable for defamation? The answer is no, because Tejasvi cannot be held for liability. Why it cannot be liable for defamation? The passage explicitly states the opinion cannot defame a person in our valid defense. So, opinion hai, so it is, we need to, there is a fine line between opinion and what defamation is going to be. Right, so beware of the facts. Fifth question: incorrect statements on slander. Which of the following is incorrect in the light of the passage? So when you were reading the passage, there was few statements that were given, and we need to identify what is incorrect among all of them. So any statement that can affect the plaintiff's business or profession is going to be defamation. Any statement that brings out the plaintiff's clandestine acts comes under the category of slander per se. So what is clandestine? It is basically a secret, right, which should not be revealed. That comes under what? That is incorrect. So B is the correct answer. So as soon as you get the answer, tick it. Okay, don't wait to read the more options. Just skim read the other options, whether they are correct or not. Because other two are like types of slander, and seeing that plaintiff has communicated some type of disease which is communicable in nature is slander per se. Gold digger allegation: X and Y were colleagues at a law firm. X told colleagues Y was a gold digger and dated people for money. After Y rejected his romantic advances and subsequently dated other persons. Had defamation occurred? Yes, there was being defamation in the given case. Characteristics of a slander, or which of the following is a characteristic of slander, is a type of defamation. It is a statement that is defamatory, but of course it is but in present in public in verbal form. It is little difficult to prove as there is no particular proof of the presented act. There are two types of slander, slander and slander per se, and all of the above is the correct answer. Questions from 8 to 11. It is basically on the nuisance, public and private. We already know what nuisance is, right? If someone is harming the peace that you have, right? Nuisance is a tortious act, of course, causing harm or offense of the public or individual. So it has to be majorly in public towards or the individual towards, right? Leading to legal liability, it is classified into public nuisance and private nuisance as well. So public nuisance basically where the community at large is at risk, right? They are being harmed with respect to someone. Private is basically where you are enjoying your own property and somebody creates something. So examples you can see: excessive noise, foul odors must be substantial, not trivial to be actionable. So something which is not tolerable. Okay, sometimes there can be a few kind of music there around your surroundings, and they can be shut down. So majorly it happens when it is Ganesh Visarjan in Maharashtra. That is a big thing, right? So majorly it is a festival, and post that everybody is normal, right? Similarly, when there is a Durga Puja, it is also happening, and then it is azans, right? So majorly they have their own times, and reasonable time is okay, right? Question 8: the bus stand shop. Joynagar was a planned urban city with separate designated zone. B, a visitor from a neighboring village set up a shop inside the city's public bus stand. Has B act resulted in public nuisance? Here, yes, the act of B has resulted in public nuisance, because by setting up a shop in a public as bus obstructs the free movement and enjoyment of the public at large. The blockade: B, the mukhya of the neighboring village visiting Joynagar parked his fortune directly in front of A's house gate. making it impossible for A to take his car out of his own property. Has there been an act of nuisance? Is there an act of nuisance? Of course, but what it is an act of private nuisance. The answer is going to be C. The 25-year shortcut, B had been bypassing through A's property in Ramgarh to reach his own house for past 25 years. A now claims nuisance and wants to stop B's use. Can Can A put an end to B's use of his land? The answer is going to be no, because A cannot put an end to the usage of his property by B. Question number 11. Incorrect statements on nuisance, which is one of the, which one among them is an incorrect statement. So, well, we see none of these are, because all the three are the correct statements. Questions from 12 to 17 is basically on defamation public figures, a saint case. Saint's defamation conduct. The Delhi High Court addressing a defamation case involving a saint, Saraswati, dismissed his plea to restrain news channels from broadcasting alleged defamatory content. Justice Subramanya Prasad observed that saints who command public respect must maintain conduct befitting their elevated status. Conduct over legal remedy. The court held that for persons in sacred influential positions, character and conduct are of paramount importance. Frequent resort to legal action may erode public faith in the saint. Higher standard of behavior. Saints are expected to adhere to a higher moral and ethical standard. They must embody the virtues they preach and serve as role models rather than engaging in legal battles over reputation. Legal recourse as last resort. The judgment reiterates that legal remedy should be the last resort, and especially for those in secret and influential position. Primary reason for dismissal. What was the Delhi High Court's primary reason? It is going to be B, where states should prioritize their conduct and characters over legal actions. That is what they have already stated here, right? Coming to consequence of frequent legal battles, according to court, what could be the consequence of saints frequently engage in legal battles? As justice, a loss of faith in the saints has to be there, right? This is also that they have said here itself in the passage. Legal recourse as a last resort. Why does the court believe that legal recourse should be the last resort for saints in defamation cases? It might damage the saint's public image, right? The answer is C. Question number 15. Appropriate response for saints. The Delhi High Court emphasized that saints should not rely on legal action to protect their reputation. What does the court suggest in a more appropriate response for saints? The answer is going to be C, maintaining exemplary conduct and character. Moving on to question number 16, role of saints in society. What principle did the court reinforce regarding the role of saints in society? Though it's a ruling in the Saraswati case. So the answer is going to be B, saints must embody the virtues they preach and serve as role models. Public image and legal remedies. Majorly, when you see the public, what did the court imply about the relationship between a saint's public image and the use of legal remedies? The correct answer is going to be C. The court implied that resorting a legal remedy could paradoxically undermine the saint's public image, the very thing they seek to protect. Question number 18 to 24 are on negligence and duty on care, where we see the negligence. Negligence is what? A breach of legal duty to take care, which results in damage undesired by the defendant to the plaintiff. There can be reasonable foreseeability, sufficient proximity, and fair, just, and reasonable. That I think is self-explanatory, but read it once. Was it reasonably foreseeable that a person in the claimant's position would be injured? This is a question of foreseeability, not probability, derived from actual knowledge and experience. Sufficient proximity. Was there sufficient proximity between claimant and defendant? Proximity is assessed through circumstances such as personal injury, psychiatric harm, or economic loss. Is it fair, just, and reasonable to impose a duty of care where a defendant exercises a special skill or profession? The standard of reasonable competent member of that profession applies. The log and the children. H was holding logs of cut trees onto a truck in the community park. He noticed two children playing nearby. While loading, he accidentally struck a child with a log. H contends he had no duty of care towards the children. Should H compensate the parents? He would. H would compensate the parent because we know this is going to be negligence. Question number 19. A truck driver left his vehicle with the keys in the ignition while eating. Boys got inside and drove it. Colliding with another truck and damaging the tables being transported, a negligence was filed against the truck owner. Now we know that negligence has to be filed, and now what are the options we have? The answer is going to be C, where truck driver is not liable because it was not foreseeable that some boys would take the truck. Of course, we are not liable because he didn't thought that there were boys and doing the mischief, right? F is an auditor of XYZ Private Limited and released an audit report. J, as an investor, relied on it and invested, suffering huge losses when it was revealed and F was misrepresented the company's profit. J filed a negligence case against F. Decide. The answer is going to be C. The audit report is prepared for specific purpose and audiences. F, as auditor, does not owe a general duty of care or potential investors. J's reliance alone does not create proximity. The helmet and the bowler are an aggressive international cricketer threw his helmet in frustration after being dismissed. The bowler, celebrating a nearby, was stuck and injured. Are content that the bowler was negligent to be celebrating so close. Is R for negligence? The answer is going to be D. R is liable for negligence because he owed a duty of care for every player. Question number 22. M ran a fertilizer factory on a leased property. An explosion damaged M's factory and nearby properties. Investigation revealed the cause. The safety valve was directed inward and rather than the open air. Is M liable for negligence? The answer is going to be A. M is liable for negligence because he was careless in directing a safety valve inside the premises. The sleeping water in the same factory scenario, the investigation revealed that the explosion was caused by water seeping in from a neighboring steel industry. And a negligence case was filed against M. Decide whether M is liable. So the answer is going to be C. M is liable because the seeping water from a nearby industry is a foreseeable event. Which of the following is not an essential condition to be held liable for negligence? All the necessary precautions were taken against every untoward incident. The answer is going to be C. The last passage is on assault, intent, apprehension, and imminence. Assault, we already know if there is a threat and apprehension of threat, right? Or attempt to inflict bodily harm, we always say that it's going to be assault. Intention होना चाहिए, reasonable apprehension होना चाहिए, imminence होना चाहिए, ठीक है? आपको imminent threat feel होना चाहिए. Somebody is coming with a punch towards me, I should feel it, right? And the threat should be there, right? बट ये नहीं होना चाहिए कि आपने पहले मारा और फिर सामने से आपको कोई मार रहा हो तो आप उसको बोलो असॉल्ट हो रहा है, ऐसा नहीं होता, ठीक है? तो दैट इज नॉट द अदर वे अराउंड. Question 25. The raised fist outside the nightclub. Raj raised his fist at Vikram from 3 feet away, shouted, "I'm going to smash your face," and stepped forward aggressively. Vikram forced, believing Raj would strike immediately. Raj then lowered his fist and walked away without touching Vikram. Which conclusion is correct? Raj committed assault by intentionally raising his fist and threatening immediate violence. Right? The gun at a political rally, Priya pulled out her gun. She was just waving and saying that nahi isme to bullets hi nahi, ठीक है? So no one was touched and nothing happened. But then it was something that a person cannot carry in a usual day, right? So the answer is going to be B. Priya did not commit because her immediate disclaimer neglected any intent to cause apprehension of immediate violence. The missed swing at the market, in the crowded market, Omar swung his fist at Tara's face but missed by inches. Tara flinched and stepped back, genuinely fearing she could be hit. So here Omar has committed an assault. The seated threat, Deepak verbally threatened Salman outside a coffee shop. "One day I'll punch you hard enough to break your jaw." While remaining seated and marking no gesture or movement, Salman heard the words but saw no action. Is this assault? Deepak did not commit assault because mere verbal threats without gesture or demonstrated ability do not instill reasonable apprehension of immediate danger. Definition of assault. Which of the most accurately encapsulates the definition of assault among all the options here? The answer is C. Assault is an intentional act or gesture creating a reasonable belief in the victim of imminent harmful or offensive contact without requiring physical touching. We completed 29 questions in majorly 25 minutes, and I think this should be your speed. You need to understand your speed and how to accurately see the question. Go for skim reading, identify the correct answer. It will be there and right in front of you. So you have to read fast. That is a major key for legal reasoning, for English and logical as well. So you have to be very good at reading, right? That is it from my end. If you have any doubts, just note it down in the comment box. And I hope you guys are practicing really hard. You're actually dedicated towards your studies because now the CLAT is really near and you have to go and clear it, right? All the very best, everyone. Bye bye. Take care.